I want to now turn it over to Alan Schwartzseid from our brand spanking new Orlando office for K. Bender Rembaum. Alan, welcome, sir. Thanks for teaching today. What you got for us?
Thank you. So you mentioned the new-ish office. I say new-ish because we've finally been in for about a month and a half, but it is so new that we actually just got the signage out front today. So if you're wondering whether Jeff really means it's new, no, we're not kidding. It's as new as it gets.
It's got that new car smell.
We hope so, at least. So I'm going to go ahead and share my screen, and I guess we'll get started. Jeff, thanks for the introduction. Everyone, like Jeff said, welcome to Covenant Enforceability for homeowners and condos associations. Co-ops, this is pretty much going to apply to you as well, but there might be a couple things here and there that you might need to do differently. And frankly, it's probably going to be your best bet in that instance to reach out to your counsel and make sure that everything is going the right way in accordance with what I'm saying today, because again, there may be differences for co-ops. I see Salvatore mentioned in the chat. Congratulations. We appreciate that. Genuinely appreciate it. I'm very happy to be back with KBR after I'll call it brief, but it was about 8-year hiatus. I rejoined the firm about 4 months ago to open this office, and we're all very excited about it. So I'll get into my very brief spiel, and then we'll just get started. I am
really briefly, if I may interject, because I failed to do this. This is my fault. Sorry for the interruption.
No, that's okay.
The chat is open, okay, but use the chat, folks, only for like technical issues. Maybe you can't hear us. Maybe something looks funny. When it comes to actually asking questions about the content, please use the Q&A. So use the Q&A for your questions. We'll have a little bit of time at the end to answer some of your questions. And again, the chat will only be for techie stuff or having issues, that kind of a thing. So Alan, sorry, pardon the interruption. Back to you, sir.
No, that's absolutely fine. Thanks for the clarification. So I am the managing partner of the Orlando office of K. Bender Rembaum. We also have our main office in Pompano Beach, as well as offices in Palm Beach Gardens in Palm Beach County. We also have an office in Tampa and Hillsborough County that Sean Brown manages. And then we also have an office that's available in Miami by appointment only. We are 21 lawyers, all practicing in this area of community association law. I believe there are now 10 who are board certified in that area. One is also board certified in construction law. A practice area that we haven't really grown until I joined the firm is we also have, I believe, either 3 or 4 certified mediators who can mediate these type of community association disputes. So if we're not your counsel and there is no conflict, a lot of these we'll discuss later need to go to mediation before a lawsuit can be filed, or at least mediation needs to be offered. So, another way that you can work with us, even though we're not representing your community or you as an individual, is in that mediation capacity. So with that said, we're really happy to present this seminar for your education. If your community does need legal representation, if any of this is not clear to your board or to your manager, or if you are a manager and just need help, feel welcome to reach out. My information is right on that first slide. We made it a lot easier than it was last time I was with the firm. My email address is as@kbrlegal.com. So again, much easier than last time, and I genuinely appreciate my partners making that happen. So let's get started. Covenant enforceability. This is what we're here to discuss today. So the most important 2 things that you need to keep in mind from today's seminar are these 2 things stated in these 2 bullet points right here. One is it's the association's responsibility to uniformly enforce its covenants. In other words, you need to make sure that your covenants, restrictions, rules and regulations, your architectural criteria, they're all being applied the same way across the board, okay? The right to enforce any of this stuff generally needs to be in the declaration or rules supported by the declaration or the bylaws. So if you're sitting here and saying, I don't like X, okay? The answer to, can I enforce that, is, well, it depends. The Florida statutes aren't going to generally say, other than what we'll discuss today, what you can and can't require in a community association. That's all going to come from your governing documents. That declaration is your contract. It's your constitution, just like the US or Florida constitutions, but it only applies, instead of nationwide or statewide, it only applies to your community, people that are living there, that own property there, and that visit there. So you want to make sure that any rules and regulations, any criteria, any policies and procedures, they're all supported in some way by that primary document, your declaration. Some people call that your CC&R, some people call it the covenants. Some people mistakenly think that the bylaws and the declaration are the same. They're not. Your bylaws are generally going to say procedurally how things are done. Declaration will generally, and I say generally because sometimes these things are totally wonky, but your declaration is generally going to say, here's how you need to operate your community and what you can and can't do and what your members can and can't do and what tenants, occupants, all these other people can and can't do within your community. Okay, you can't retroactively create these other than by an amendment to the declaration or the bylaws. Otherwise, if the rules don't exist or they're not clear, in other words, if it's unclear what the owner's actual obligations might be, in other words, I don't know whether I'm allowed to do this or not, my suggestion is either create rules and regulations that are already supported by that declaration or amend the declaration, which may not be an easy task. You may need to start by amending the amendment provision to make that even feasible, but you want to amend your declaration so that it does support the restrictions that you're trying to put in place and enforce. Okay, so we go forward and we move on to this directors owe a fiduciary duty. Now, when we say directors, that also includes the officers. But this fiduciary duty is owed to the members of the whole, not the individual members of your community, as well as the association, the corporate entity. Because keep in mind, what you're doing as a director is running a business. It's not a for-profit business where you're trying to make millions of dollars, but it is a business. And when you make your decisions as a board, you need to make business decisions rather than emotional decisions. When you get emotional, frankly, that is where we see community associations getting into these huge fights and huge lawsuits rather than, okay, well, our business decision is to proceed, or our business decision is to say, we're not really willing to take this risk, rather than, I hate this guy, I'm going after him. Okay, so that fiduciary responsibility means that you might need to do what you reasonably believe in that business judgment is in the best interest of your community as a whole, rather than your own best interest, even if it would hurt you, whether that's because emotionally you don't like someone or you don't like what they're doing, or it might financially hurt you when there's a conflict of interest. Okay, conflicts are not something we're going to get into, but they are a big issue in community associations. And when I say conflicts, I don't mean people fighting. I mean, you have a financial interest or someone in your family has a financial interest in a board decision. You need to step away from that as the bottom line. There are certain things you can remain involved in, including as a member of the community. But again, we're not going to get into that in depth. So one thing that I think is really important that I mentioned a minute ago is this consistent uniform enforcement. Okay, there are three things that your enforcement process needs to be in order to avoid almost every defense that exists to a covenant enforcement lawsuit. And when I say almost every one, I literally wrote the book on the subject. That's not me bragging, but it goes to say there are HOA and condo books that are being published in the next, well, it's been in publication for the last 2 years, so I won't say exactly when, but in the next few months to a year, hopefully, they will be published, and they are the Florida Bar Condominium and Planned Unit Development Committee establishing these things. And I wrote covenant enforcement defense chapters for both of these books. So I might know a little bit about what we're talking about here today. And timely, consistent, uniform enforcement means that there's really not much of a defense to any enforcement action. Just like when you're going in and enforcing non-payment of assessments, there's really not a ton of defenses. Well, unfortunately, when it comes to covenant enforcement, you really are the one creating defenses if there are any. Okay, so we talk about timely enforcement. What we're talking about there, and I did get a question about this via email just before we got started, so I'll answer that briefly just by what I was already planning on going through. There is a 5-year statute of limitations on any enforcement activity. So if you knew or should have known about, let's say, someone painting their house and you come after them 7 years later, well, chances are it's too late to go after that based on the statute of limitations. Similarly, there's a defense called latches. That's essentially you snooze, you lose. That's the legal terminology, but that really is what it is. It's if you cause someone to believe you're never going to go after this by not acting on it for whatever the time frame might be, and they actually throw away or get rid of or lose evidence that they could have used to defend your case, your enforcement lawsuit, that's a defense to your lawsuit. Okay, so those are the two timeliness defenses. Then we've got consistent and uniform enforcement. Okay, consistent, we have waiver and estoppel. They're pretty much the same thing. The difference is estoppel is usually going to be something that's in the interest of fairness, and it's your conduct. Either you did something or chose not to do something or didn't even think about doing something for a reasonable time frame, and as a result, this owner was led to believe that it was okay to do what they were doing. Waiver is very similar, but you put in writing that you're not going to enforce this. Okay, and then finally, uniform. We get into selective enforcement is the last major affirmative defense that people raise when you file a lawsuit seeking to enforce your covenants. That basically means, well, John was able to do it down the street. I can see that he did it. Everyone can see that he did it. Why can't I do it too? I'm just going to go ahead and do it. And when you go ahead and complain about me doing it, this is what I'm going to raise. Well, if you let him do it, I was led to believe that I could do it. It's similar to estoppel, but it goes a little bit more in depth. I won't go that in depth because we just don't have the time for it today, but there's more into it than I thought I could do it. Okay. When you follow this timely, consistent, uniform policy, and by the way, you should have a written covenant enforcement policy in place, not just well, here's what we do, because that here's what we do might not be passed along to the next board of directors or the next property manager. Okay, you want to have something in writing that people can go back to and say, I knew exactly what was going to happen if I messed around with the association and violated these covenants. It's going to say you're going to send 2 or 3 letters, whatever that may be, about the violations, saying you need to cure the violations. And after that, it's going to go to your attorney to take care of these violations for you. Okay. And it's going to say, sometimes it's going to say when you're going to be fined versus a standard enforcement policy versus self-help, going onto the property and curing the violations yourself. So you should work with your attorney in preparing that policy, but it should be something that is in writing, is a resolution of the board that's been formally approved at a board meeting that was properly noticed, etc. And it's something that should be in the association's official records and potentially even recorded in the county public records so that anyone in the world is considered to be on notice of what this policy requires. Okay, same with rules and regulations. Some communities don't have to have those recorded. That doesn't mean you shouldn't record them. I'd speak to your attorney about whether that's a good idea or not. If your attorney is not us, I don't really understand why, but feel welcome to reach out if you want to make that happen. Okay. So again, we want to avoid these major defenses, maintain the board's credibility in that we're not taking action or taking inaction that leads people to believe we're going to do something other than what's in that policy. And we're going to ignore violations, or we're going to enforce only against these people or these types of people or these types of violations. The only other reason that you might have a defense, which isn't technically a defense under the law, but which might still avoid your enforcement attempts, is when you have a vague language or an invalid amendment where it's not really clear what's required of the members. Okay, so again, we go back to the fiduciary duty. You got to do what's in the association's best interest. I'm not going to probably mention that again, but again, these 2 items, this slide right here might be the most important one that I could possibly present to you today. So please keep all of this in the back of your mind while we're discussing literally everything else that I say today. So moving on, some of the specific covenants and restrictions that the board might need to enforce that might be included in your covenants, in your rules and regulations, etc. Architectural standards and what happens when someone is trying to, change the view, the look of their property. So, you might have these architectural standards in place. If you don't, and you have an architectural review committee, that's another thing that you really need to put into place, because otherwise owners could basically argue, well, I didn't know what the standards were. It's totally arbitrary and up to each individual architectural review committee, each iteration of that committee, to decide what is and isn't allowed in the community. And there's no reason that I should be aware of the fact that this would or wouldn't be allowed. So put those standards in place if you've got an architectural review provision in your governing documents. Again, that's something that should be in your official records, approved by the board, and perhaps recorded. Same thing, age restrictions in a 55 and older community. Those are really some of the only age restrictions you're allowed to have. Pet restrictions. And along the lines of pet restrictions, one thing that I like to point out, I mentioned vague provisions. Specify what pets are and are not allowed. Are we allowed to have household pets? Well, what is a household pet? Because according to some definitions, that includes a miniature horse. That includes an alligator. That includes chickens. If someone has it in their household, technically it could be a household pet. So put in there, we only are allowed to have these 5 types of animals, goldfish, other fish, dogs, cats, smaller birds, whatever you want to do, but be specific. And then if you want to be even more specific, talk about breeds. Now, there are a whole host of other issues that get involved when you talk about breeds of specific animals. So I'm not going to go in depth about that. But again, this is something you'll want to discuss with your attorney. Then we get into restrictions on leasing and sales. Those need to be very explicit in your governing documents. And there are limitations on which ones of those will apply and to which owners within your community. So be careful about that. If you're implementing it now, just talk to your attorney about, well, will it apply across the board, or will it only apply to the members who actually buy in afterwards or approve the amendment? And then you've got guest and occupancy restrictions. I'm dealing with some of those right now. Parking and vehicle restrictions. Are you allowed to tow? Put that in there and make it very clear. And then nuisance conduct. Again, you've got anything that would interfere with the customary use of the property, as many nuisance provisions. Well, what constitutes the normal use of the property? What is interfering with that? Is that loud noises? Is it someone whose stormwater runs off onto my property? I don't know. So you want to be as clear as possible with respect to all of these specific items, and make sure that you're vague enough and broad enough that you encompass all the circumstances you can anticipate coming across, while still being clear enough and precise enough that it's obvious what the association actually is prohibiting versus allowing. So I know that that's not an easy tightrope to walk, and that's why you get your attorney directly involved in drafting these amendments. And frankly, by the way, one thing that I've seen fairly frequently is, well, just draft it however you think is best. Well, I don't know what you think is best for your community. So your attorney does need your input as to, well, what do you actually want to restrict? When you say, I want restrictions on leasing, do you want a right of first refusal? Do you want to be able to look into these people that are potentially buying or leasing? Or do you just want to have a copy of the lease and a copy of the person's ID that's going to be living there? There are very different levels of what you can put into these restrictions, rules, and regulations. And you want to make sure that it's clear, okay, this is what we actually want, because otherwise you're going to be paying your attorney a lot more to modify that, because they're not going to be capable of producing what you're looking for because you didn't tell them what you want. So be very clear in working with your attorney, not just handing it off to them to prepare it. Work with them as to what exactly you want in there, what you are seeing that is causing you to put this provision in place and you don't want it to happen anymore, or you're trying to protect against X rather than we want a leasing provision. Okay, so the first step in any enforcement action, you shouldn't expect someone to stop an activity that's prohibited or a condition on the property that's prohibited until you actually tell them to stop. They're going to keep doing what they're doing because either they didn't know that what they're doing wasn't allowed, or they don't care. So if they didn't know, they're definitely not going to stop. If they don't care, your letter to them telling them, hey, we noticed what you're doing. We're not blind to it. We're going to pursue it if you continue down this road, gives them notice, hey, our intent is to enforce our restrictions. If you don't send that notice, they have no idea that you're, I won't say upset, but that your intent is to move forward with this enforcement mechanism. I don't know how that just zoomed. I apologize. There we go. So, you mail the owner, and you might email them as well. Notice of the violation. It should say this is a violation, preferably also pointing out what provisions of your governing documents or your rules and regulations actually say they can't do this. So that they're on notice of, hey, we're not only relying on these provisions, but it seems pretty clear from our our view as a board or as your property manager who is perceiving this, that this is not allowed. And here's why under the governing documents. You also want to provide a deadline for compliance. In other words, if you don't comply by this date, the letter should say, here's what we're going to do next. And that should come directly from your enforcement policy that I mentioned earlier. It should say you're going to get another notice, or this is going to be sent to council, or we're going to start, depending on what's in your governing documents, and only if it specifically says so, we might start, accruing attorney's fees and costs that might be chargeable to you as the owner or you as the violator, etc. If they don't comply with that deadline, and some people will give 5 days for mailing just because the mail is extremely slow right now. If they don't comply with that deadline, you take the next step in that process if they haven't done anything to cure the violation. In other words, if you told them you need to cut the grass, that's something that they can get someone out there 2 days later. Okay. If within the 2 weeks that you're providing in this letter, they haven't done it, there's no reason for you not to take that next step. Okay. So, if they don't comply with the demand, you move forward, whether that's to your attorney, to arbitration, or to mediation. That's up to the board. And again, is going to be probably dictated by your customary enforcement policy. Okay. So we're going to talk about fines. I'm not a fan of fines unless they're done right, and they rarely are. And this is why I say this. Okay. When you are fining, you're really acting as judge, jury, and executioner. You're giving yourself complete free reign to decide what a judge would normally decide. You're taking evidence at a hearing, and we'll go through this process in a minute, but you're taking evidence at a hearing, you're deciding on that evidence, and the fining committee is saying yay or nay as to whether this person is in violation. That's really an entire lawsuit in a single hearing. What you're doing is a final hearing. Okay. And judges don't necessarily like that the fining committee can make that decision for them. Okay. So a judge is going to do this whole process all over. Now, that judge also requires that you're willing to file a lawsuit to enforce these fines. And that's why I say 99% of communities I've represented since 2010, their answer to, well, yeah, you can levy these fines. Your governing documents allow it. The statutes allow it. But are you ever going to do anything with them? Are they just going to be listed on an estoppel a year from now? And then they'll be the first thing that you guys agree to waive when the owner says, we want to pay you less than the full amount that you say is due at closing. Okay. So again, you're killing the board's credibility by saying, we're going to levy these fines. We're going to go through this whole process. We're going to take the time to do this the right way, but we're not going to do anything after the fines are on the account. We're just going to tack them on, and we'll deal with it whenever the time comes. And again, don't forget that 5-year statute of limitations. If this person doesn't refinance or sell their property within those 5 years and you don't file your lawsuit, those fines disappear. Now, they can also be avoided in bankruptcy, but that's what we're dealing with. So when I say if you're going to do it right, that means before you even start this fining process that you're prepared to take it as far as it needs to go by filing what is likely a small claims lawsuit. Now, we'll talk about other options. You might be able to lean for it, but only in specific circumstances and only in an HOA. Okay, so again, only levy if you're going to pursue these fines in court. If you're not going to, go through your standard enforcement process, or if you've got the option under your governing documents, I would prefer self-help, which means you're going ahead onto the property after giving notice and curing the violations yourself. Okay, I don't have a problem with fines. I just have a problem with fining and then leaving them on the account for 10 years, which they're not being collected. So what was the point in the first place? So eventually people get to learn about the fact that the association is not going to enforce that. And they basically say, yeah, if they're not going to do anything about it, I don't care if they fine me. I'm never going to pay it. So you want to give the impression that if you're going to levy these fines, someone's going to get sued if they don't pay them. If you're going to go to that extent, I'm fully supportive of fines. Okay, now that we've gone through all that, there is a case that is Metropolitan-Dade County versus Chase Federal Housing. Basically, a statute is not retroactive just because it's applied retroactively. What we're saying here is that you're not going back retroactively and saying, well, the statute says that I can fine even if it's not in my governing documents. You're not saying that. Okay, there are procedural issues, there are substantive issues, and before you fine the first time, your attorney should really be doing an evaluation of whether your governing documents allow or prohibit that fining process and whether the statute applies and you can fine. Generally speaking, you probably will be able to, but rather than send a demand for payment of amounts that you cannot collect and potentially be dealing with a fair debt lawsuit, either under Florida or federal law, I strongly recommend just spending what will probably be less than a half hour having your attorney make a decision of whether you're allowed to levy those fines or not. There are limitations on the amount of each fine. It can't be more than $100 per violation, and it can be levied on a daily basis for continuing violations up to $1,000 per violation, unless your governing documents say otherwise. So I've have some communities in South Florida that their governing documents say you can continue fining every day, just like a municipality could. So you got your county code enforcement or your city code enforcement. It's $100 a day for 2 years. Okay, well, that person now owes, that $100 times 365 or 366 times 2. Okay, so that is a possibility. It's not a distinct one. It's only if your governing documents say so. Now we get into, the lien issue that I mentioned a minute ago. A fine of $1,000 or more may become a lien against the parcel, and it can be collected through that lien foreclosure process if your declaration says so. Now, the statute actually says a fine of less than $1,000 may not become a lien in an HOA. There are no liens at all in condo. We'll get to that in a minute. Okay. The question is, does that mean that a fine of $1,000 or more can become a lien? Probably, if you read the statute logically, it would be pretty much meaningless and a little bit ridiculous if the statute were intended to say, you can't fine at all, because at that point it would just say, just like it does in a condo, a fine may not become a lien. But there's still something that an owner could come back and argue that you need to be aware of. The fact that your governing documents say you can move forward with that lien foreclosure process isn't necessarily an automatic. So just keep that in mind. So here's the process. You need to have a hearing. Now, the first thing you need to do is give notice of the intent to fine. The board basically decides we're going to levy a fine against this person for doing X. Okay. Then they send it to your fining committee. The fining committee will then schedule an opportunity for a hearing with written notice of the violation, opportunity to attend a hearing no sooner than 14 days from the date of the notice. In other words, you send them a letter saying in 14 days we'll be holding a hearing. And the committee that is going to hold that hearing needs to be at least 3 members appointed by the board who aren't, and this is why it can be difficult to find these people, are not officers, directors, or employees of the association, or their spouse, parent, child, brother, or sister. Okay. And keep in mind, this includes spouses, children, siblings of employees. Now, that's one reason it's difficult to find these people. The other reason, most people don't like being fined, and they will go after these people if they are, the type to be extremely aggressive. These people and the board and the manager are the first people that these people that are being fined will send nasty grams to and mean emails and call. And I can understand that. There are things that the association can do when that happens. The first thing you should do is contact your attorney, by the way, but it can become really difficult to embody this committee. And if you don't have the committee, there are no fines, period. It's not well, we tried really hard, but we only had 2 people. Okay, then you don't have a fining committee and you don't have fines. So just keep that in mind. If the committee doesn't approve the fine after that meeting, the fine doesn't get imposed. In other words, this committee gets to decide yay or nay. Okay, if the committee says yes, the fine is appropriate after that hearing, then the fine's due 5 days after the board gives notice of the fine being approved to the owner. Okay. Now, the notice needs to be provided, meaning it might need to be hand delivered. It might need to be, and I don't recommend hand delivery of fining notices. It might need to be received via email or mail, etc. Now, none of these meetings, just to be clear, are closed meetings. They're all open. The question becomes, do you need to offer or actually hold this fining committee meeting? In other words, if no one shows up and no one says, I want a hearing, do you need to hold what is the equivalent of an evidentiary hearing? To be safe, my answer is, yeah, you do. But there are a lot of attorneys in Florida who will tell you, absolutely, that's not necessary. You just need to offer the opportunity for that hearing to take place. And if they don't respond within 14 days, you move forward and the committee can approve the fines without a hearing. I disagree, but I don't frankly know what the rest of the attorneys in our firm feel. My perspective is always be cautious on these issues because you don't want to screw up that process. And it's very easy to just have these people meet via Zoom, share the link, and give the opportunity for anyone who wants to present their evidence to show up and state their cause and state their case. There is another case, Tahiti Beach versus Pfeffer, that basically says that this fining statute is remedial and penal in nature, and therefore it supersedes a declaration's provisions to the contrary. In other words, if the declaration says something other than what the statute says, the statute might control, okay, over the declaration. So again, things to keep in mind, things that you should probably discuss with your attorney before levying any kind of fines. In condos, yes, you can fine. The process is the same. The authority to fine does not have to be provided in the governing documents in a condo. The same fining process and dollar limitations apply, but you can't have a fine become a lien in a condo. You can use that fine as the basis for a suspension of use rights and to disqualify a director. In other words, if it's 90 days past due after that 5-day notice period, then you can use that as the basis to say you can't use certain things, and we'll get into that right now. Okay, so you can suspend the rights of the owners, occupants, essentially anyone that's affiliated with a unit or a lot in an HOA to use portions of the common areas, common elements, common facilities, and any other association property. We're talking about pools, gyms, clubhouses, rec rooms, and all the other facilities. Basically the fun stuff in the community. You can say you're not allowed to use that anymore, as well as the owner's voting rights if they are 90 days delinquent in any monetary obligation, including fines, including assessments, including key charges, whatever it may be, that are due to the association. In other words, if they owe money for more than 90 days and haven't paid it after it was due for those 90 days, then you can suspend those rights, okay? The suspension does need to be approved by the board at a duly noticed board meeting. The suspension doesn't apply to certain areas, okay? So that's the common areas and elements used to provide access to the parcel, okay? Now we get into when we're talking about ingress and egress, which is access to the lot, the unit, we get into the issue of, well, what if I shut down the key fob at the gate? In other words, we've got a guard gate, and if your fob isn't working, we turn it off, you got to show your ID in order to get into the community. Judges, from what I've seen, go about 50-50 on that issue as to whether that is blocking ingress or egress. My argument for the last decade plus has been that is blocking one method of getting into the community. We're not saying you're not allowed in. We're saying you have to show ID. And again, judges go about 50-50. You're taking a risk by doing it, but it can be an effective tool, especially when the property is rented and the tenant says to the owner, hey, you need to do whatever it's going to take to get me to be able to use that key fob, because this shouldn't be my problem that you're not complying with your obligations. Okay. Now you're not going to tell the tenant that they're not complying. You're just going to say that the rights have been suspended. But that's where we go with it. Okay. So you can't shut off utility services, which might or might not include internet. If that's provided by the association, I would say to be safe, internet is pretty much a utility, even if it's really not. So I think that's one you're going to need to discuss with your attorney before you decide to do any of these things, other than send the notice of suspension. And you can't impair vehicular and pedestrian ingress and egress to the parcel, including the right to park. So like I said, you can't block the condo elevator. That's obvious. But can I require them to check in at the desk? I don't know. So keep all this in mind. In a condo, the suspension can't include limited common elements that are intended to be used only by that unit, common elements needed to access the unit, utility service to the unit, parking spaces or elevators. And that's going to include pretty much anything. You can't say you can't go on your balcony because you haven't paid this fine that was levied 3 months ago. There is 2017 condo specific legislation. The monetary obligation needs to be $1,000 before you can, or greater, before you can suspend these rights, and you need to provide at least 30 days before you do so. Before you suspend voting rights in a condo. So, we talked about most of what I like to discuss. The question is, let's say you owe $50,000 and you pay $49,999 of that. And that 1 cent is still due and it's still 90 days past due. So what does the association do? Well, that's up to the association. Technically, that 1 cent is 90 days delinquent. And the association could say, until you pay us that penny, we're not turning your key fob back on. We're not allowing you to use these common facilities. Okay. Practically speaking, that's one reason it's so important to keep your financial records accurate, because if you're off by a penny, then you may be restricting someone's use rights and you might have no basis to do it. And then you get sued for making that error. Keep in mind also, when a voting interest is suspended, it doesn't count for any purpose. That voting interest is a nullity. Meaning if you have 100 members and 5 have had their voting rights suspended and half the membership is a quorum, you now only have 95 possible votes to potentially meet that quorum and hold your meeting. So you might be, I think the phrase would be cutting off your nose to spite your face if you are suspending those voting rights. I'm not saying it's not a useful tool. It definitely has its use and you should use it, but just be careful with the way and the timing of what you use it. Another avenue that's not mentioned here is a rent demand. If the owner is delinquent in payment of any obligation to the association, any monetary obligation, and there is a tenant in the unit, you can send that tenant a demand that basically says you need to pay the association directly until the account is brought current, at which point we'll send you a letter letting you know you can send your rent directly to the landlord going forward. And the statute is very clear that sending the rent to the association instead of the landlord can't be held against the tenant as a breach of the lease. So just another thing to be aware of that you might want to confer with your attorney on if you know that the property is rented and the owner's past due in assessments, fines, etc. So to take effect, the written notice of the suspension must be mailed or hand delivered to the parcel owner, like I said, and if applicable to the occupants, licensees, or invitees, in other words, the other people that might be using the property. If the voting rights are suspended, I just mentioned the vote just doesn't count at all. There's also recent case law that I'll add, the De Soleil South Beach case. For declarations recorded before the effective date of the amendment that authorized these voting suspensions, which I believe was 2010, the authority to suspend voting rights must actually be found in the declaration, or the declaration needs to contain what's called Kaufman language. In other words, it applies the Condo Act as amended from time to time in order to suspend voting rights. In other words, if your deck doesn't say you can do it, you can't do it, even though the statute says you can. I don't think that's going to be applied to suspension of use rights, which are kind of a lesser right to some extent. But again, confer with your attorney and make sure that you're allowed to suspend these rights before you choose to do so. Now, there are some of these things are just by the board, like I mentioned. There's also the suspension by a covenant enforcement committee. In other words, people are not complying with your covenants. You can suspend their rights for that reason as well. Okay, again, this is for a reasonable period of time for pretty much anyone affiliated with the unit or the lot. You can suspend the right to use those same common areas, etc. You can't suspend use of the portions that are required to provide access, etc. Essentially, the things we discussed earlier again. And the suspension can't be imposed in this instance, in other words, for covenant violations, unless the violating party has had an opportunity to appear before the committee on that particular issue. In other words, we're going through pretty much the same process as you would with a fine. You get the board to decide you want to suspend use rights, the opportunity and the notice comes out that you will have a hearing before the covenant enforcement committee, which might be the same as the fining committee. It's usually going to be different, but sometimes it's the same people. And then once that committee meets and hears whatever these people want to say in their own defense, they decide and they report back to the board, and there is a report of whether the suspension carried or whether it was denied by that committee. Okay, now we get into mediation. So I love mediation. I mentioned earlier, I am one of the attorneys within the firm that practices in that area. It is not a legal area where we are representing either party, but it is a procedure whereby the parties get together in a room or on Zoom preferably, because that costs everyone a lot less. And they make a decision of, okay, is there anything we can do to get this settled? In other words, we've got a dispute, we disagree on something, and here is a list of those disputes that are subject to that pre-suit mediation. Okay, you've got use of or changes to the property or common areas. In other words, covenant enforcement, amendments to the governing documents, meetings of the board. In other words, that includes meetings that are not being held or meetings that are being held improperly, and committees appointed by the board, membership meetings, not including the election, which is governed by a separate process, access to the official records. In other words, I sent a properly worded and issued records inspection request. And when I say properly worded, it literally just has to say, I want to inspect and copy the association's records. It doesn't have to be specific. And then again, covenant enforcement is the other one. So there is a reason I got certified as a mediator. It works. In many cases where parties didn't think they'd be able to resolve a dispute because they were literally hundreds of thousands of dollars apart in settlement figures. One, I literally had a $5,000 offer as compared to a $250,000 demand. We ended up settling it after an 8-hour mediation. And that was a condo pipe leak issue. And so you never know what you're going to be able to settle during these mediations. And that's why the legislature actually changed the law to say, and this is a while ago, but it changed the law to say, listen, rather than just go straight to court and file your lawsuit, we want to see if we can get these things settled and kind of alleviate some of the burden on the court system. So that is something that I really enjoy is mediation, whether I'm representing the association or if I'm the mediator. It's something that I think is a really worthwhile thing to do. There's also a Moriello is the name of the case, a decision in April 2022 to keep in mind with respect to these demands. If you have the right to perform self-help, in other words, in your declaration, it says if the owner violates this provision or any provision of the governing documents, you can go in and unilaterally tell them, hey, we're giving you 10 days. If you don't fix this problem, we'll fix it for you and charge the cost to you as an assessment against your lot or something similar to that. This case basically says before you can go after an injunction in particular, it doesn't say before you can file suit, but before you can seek an injunction in court, you actually have to at least threaten and pursue that self-help remedy. So again, you might want to talk to your attorney and make sure that you've got the authority to do that self-help before you even consider threatening it. And if you do have that right, you also want to talk to your attorney about whether it's a good idea to go onto that property. For example, I've had self-help rights that are universal across the board. My client's not going to go onto someone's roof, tear it off and replace it. So you've got to make that business decision of how are we going to pursue this. But I did want to make sure that everyone that's listening today is aware of this newish decision. And I say newish because it's based on a decision that's 10 years old. I just hadn't seen anyone attempting to enforce it until this April 2022 opinion came out. So it's almost a year old. We're starting to see people using it as a basis to try and get out of an injunction case. So just be aware of it. Discuss it with your attorney. Disputes that are not subject to pre-suit mediation. Collection of an assessment, fine, or other financial obligation. In other words, if you're owed money, that doesn't need to go to mediation. Enforcing a prior mediation settlement agreement, that goes straight to court. You're not enforcing the declaration at that point. You're enforcing the agreement itself. It's just a contract issue. Okay, you've got eviction or removal of tenants. That is not subject to pre-suit mediation. Alleged breaches of fiduciary duty. In other words, the directors or officers did something that is really egregious, at least in the person's mind who is considering filing that lawsuit. Recall and election disputes are all going to go to the Division of Florida Condominiums, Timeshares, and Mobile Homes, and then disputes among parcel owners. In other words, if you're angry at your neighbor, you don't need to go to pre-suit mediation. Now, I have seen it where in the past I've represented owners. I sent a mediation demand. The owner's counsel responded, we don't have to go to mediation. And I said, I understand that, but we're trying to get this settled, not to sit here and sue you. And we ended up settling several of them. So just keep in mind, it's an option, but it's technically not a valid demand is what I'm saying, unless the association is also a party in that dispute. Okay, so in condos, most of the disputes that are subject to pre-suit mediation, you can choose binding or non-binding arbitration instead. I don't necessarily ever recommend that you do so. And the reason for that is Arbitration can tend to cost more. You're basically going through a mini lawsuit, and then you have to file a lawsuit to enforce the arbitration award if the owner doesn't just go ahead and comply. The other reason is that there is literally a ruling out there that says that arbitrators can decide arbitrarily. What that means is that the arbitrator, who is basically the one ruling on your dispute, whereas in mediation, you get to make the decision, but an arbitrator can say X in case number one, and in case number two, concerning the same type of dispute, the same parties, the same facts, the same case law, the same arguments presented, this same person, this arbitrator, can decide completely different for absolutely no reason whatsoever, and that's totally okay. So I recommend mediation and then going to court, because there is established precedent that the judges should be following, and if they don't, then that's what your appeal process is for. You want the most straightforward course towards that enforcement and the owner actually doing what they're supposed to be doing. Okay, so in a condo in particular, getting back to this, and that arbitration is not necessarily one of the options or mandatory in an HOA, by the way. This is just something that's in condos. The mediation option is actually the new one in condo world. So this is going to be the authority of the board under the law or association documents to require an owner to take action. In other words, covenant enforcement, alter or adding to a common element. In other words, you're changing the look or whatever of these common elements. And the board's failure when they were required to properly conduct elections, give adequate notice of a meeting, properly conduct a meeting, or allow inspections again. Okay. Again, condo disputes that are not subject to pre-suit mediation, you can go straight to court because it's not a dispute at all under the statute governing title to a unit. In other words, a transfer was invalid, a tenancy is invalid. Assessments, again, they're not disputes under the statute. You go straight to court after complying with the required statutory notices and filing your claim of lien. Evictions or removals of tenants, alleged breaches of fiduciary duty, and claims for damages to a unit based on failure of the association to maintain common elements. So again, going back to the disputes that I mentioned earlier, technically, those weren't subject to pre-suit mediation. The one that I said was like $250,000 apart, but ended up settling at mediation. It didn't have to go to pre-suit mediation. The parties chose to try and get it settled before they spent another $50,000 on each side litigating this in court. Fortunately, they paid me a lot less than $50,000 per side. Okay, so additional disputes that are just not subject to pre-suit mediation, mandatory arbitration in these cases with the division, recalls, elections, pet issues, material alterations to common elements, hurricane shutter issues, nuisance issues, unit access issues, and disputes between and among a parcel or unit owner and between a parcel or unit owner and a tenant, unless, again, the association is a party to that dispute. So the actual offer to participate in pre-suit mediation, the form is in 720.311, and that form applies to condos and HOAs. The condo statute just refers back to the HOA statute. So it's the same form either way, the same format and method of delivery. It needs to be sent by certified mail, return receipt requested with a copy by regular mail. It lists 5 acceptable mediators and provides 20 days to respond by certified mail agreeing to mediate with one of those 5 mediators. Okay, if the owner agrees, the parties mediate within 90 days and they share the mediator's fee equally, or an impasse is declared and you can file your lawsuit. If there's no statutorily compliant response within that 20 days, the respondent, meaning the person that received that notice, waives their right to recover attorney's fees and costs, even if they win the lawsuit, if one is filed. So this is a real benefit to associations of, well, we got to send this out. We got to wait our 20 days, but we're taking a lot less risk if the owner doesn't bother responding and we file a lawsuit. I was successful in arguing in 3 different cases over the last 3 years that the owners didn't statutorily comply with the response requirement, didn't agree to the right mediator, didn't respond via certified mail, etc. And as a result, the judges found, they would not be entitled to their attorney's fees and costs, even if they won the lawsuit. Now, they didn't win the lawsuits, but if we hadn't settled 2 of those and the association hadn't won the other one, we wouldn't have had to worry about ending up having to pay out the other side's attorney's fees and costs if the association didn't win those cases. If the mediation impasses or the offer expires with no response, the complainant, meaning the association or whoever sent the offer, can file a lawsuit or possibly a petition for arbitration. Now, the content of this letter is essentially, hey, here's the violation, here's what you're doing wrong, and here are the provisions of the governing documents and the Florida statutes that it violates. I just wanted to mention that because it's not in the slide, but it is important to know this is the content of that letter. And it basically says, we're offering pre-suit mediation. Here's what you did wrong. Here's why it's wrong. We're offering pre-suit mediation. Here's the 5 mediators we'll use. And if you don't respond within the time supplied, we'll go ahead and file our lawsuit against you. Okay, if you're going to arbitration instead, you send a notice of intent to file an arbitration petition. It's just a letter that says you intend to file and why. If that notice expires without curing, the petition for arbitration is filed in a division approved form with a $50 filing fee. And the arbitrator determines whether the division initially has jurisdiction. In other words, whether they can actually decide this issue, whether it is a dispute that the division is supposed to decide, and then whether the fee is paid. If the answer to either is no, the petition gets dismissed and you can move forward in court. If both of those are yes, the arbitrator is going to provide the respondent, meaning the party that didn't file the petition, a copy of that petition and 20 days to respond. If there are no disputed issues of material fact, in other words, issues that are actually going to be dispositive, they're going to decide who wins and loses, and there's no meritorious defenses that are raised, in other words, not just paper defenses, but actual things that, if they were correct, would be a defense to the claims that the association is raising, the arbitrator is going to basically say, hey, there's no reason for a hearing on this. I'll just issue a final order. If there is a dispute, then a date gets set for a final hearing. And then within 45 days from the final hearing, this doesn't always happen, but it's supposed to, the arbitrator is supposed to enter a final order that says who wins, what the other party is supposed to do, and if you've properly submitted your fee request, what amount the other party is required to pay in attorney's fees and costs. If no trial de novo, meaning a new trial saying, well, there was an error in the process, if the party doesn't seek that in court to challenge the final order within 30 days after it's entered, it can no longer be challenged and it can be enforced in court. In other words, you got to wait 30 days after that final order is entered to file your lawsuit. Arbitration ordered mediation might also be required under the arbitration rules and also the Florida Administrative Code. And then fees and costs, like I said, can generally be awarded to the prevailing party, but keep in mind, your attorney should know they're going to need to actually file a motion within a specific time frame before they're going to be entitled to this. And again, if none of this results in a settlement or a final order is entered and the owner doesn't comply, you still got to file your lawsuit, which is why I say arbitration could be a great program, but you're probably going to want to just go ahead and go with mediation. And if mediation doesn't succeed, just file your lawsuit. That's going to give you a better chance at getting an amicable resolution or a judicial resolution of the dispute that you're dealing with. And with that, we are done with the presentation. What if your governing documents and statutes are silent? Can the board make rules? The answer is yes, but only rules that are supported in some way by your other governing documents. In other words, if the declaration doesn't say that you have the right to screen tenants, you probably won't have the right to do it just because you enact rules and regulations that say you do. So it needs to be supported by and not contradicted by any of your governing documents. That's what needs to be the rules and regulations. Question 2, can a condominium decide not to screen buyers? The condominium is screening renters. Depends on your governing documents whether you have the right to screen renters or buyers. And if you don't do it, then you're basically giving up potentially your right to do it in the future. So my recommendation is always timely, uniform, consistent enforcement. That would not be consistent enforcement in saying we're just not going to do it even though the documents say we can. What are the benefits of having rules and regulations in the public record? Can you give examples of why this is good? Having it recorded in the county public records gives literally the entire world notice of what your rules and regulations say. In other words, people can't come in and say, well, I was just a tenant or I was just there for a little while. I had no way of knowing what I was required to do in your community. Or owners coming in and saying, well, I didn't get these documents at the closing on my property, so I didn't know what I was required to do. Well, you have the ability to look in the county public records. And so you knew about these documents, you knew about these rules and regulations, just like you knew about the declaration, the bylaws, and the articles of incorporation. So that's the answer. It's one less excuse for people not to comply with your governing documents. If there's nothing in the bylaws or a declaration, okay, so we went through this. If it's not in the bylaws or the deck, I'm going to move on to the next one to save some time. How does Florida home business support get resolved with an HOA's no business declarations? Generally speaking, if your governing documents say you can't have a business in the community, you can't. You can probably be allowed to do, Zoom and generally speaking, what your restrictions are going to say is you can't have anything that impacts the traffic, that impacts the roads, that impacts basically visibly impacts your property. So generally, when you're talking about home businesses, as long as you're not talking about storing a bunch of trailers on your property and having your workers coming out, or even having, people coming in and out with their dogs, and you've got 3-4 people a day, whereas every other homeowner just has a visitor once in a while, you're probably going to be okay. But it just depends what's in your governing documents is the answer. During the period of the current emergency powers put in place by the governor, can the board override the governing documents, specifically selling common property? There is not, to my knowledge, a current state of emergency in place. There are specific statutes that will govern what the association can and can't do. Generally speaking, from my recollection, but I'll be candid, you'll probably need to consult with your attorney. But the statutes governing what happens during a declared state of emergency are very specific as to what rights the association has that they wouldn't normally have under their governing documents. I don't believe the right to sell common property is included. Cleaning up and doing things like that are definitely included, but I don't believe that selling the property is there. Next question, a homeowner installs landscaping on community land. Is there a time limit when this land becomes their land? The short answer to that is no. It's always, community property. That doesn't mean the owner won't argue that you allowed that specific thing that they installed, that specific landscaping, by allowing it to be there for, let's say, 10 years. But, some communities will choose to say, well, it's our land. That hasn't changed. We have the right to remove anything on our land. And so we'll just go ahead and remove it and see if the owner sues. So that's, it's, like I said earlier, depends what risks the association wants to take is the answer. But is there a time when it becomes someone else's land? No. There is something called adverse possession in Florida. You might want to consult with your counsel on that particular issue. It generally probably won't apply to the circumstances you're describing, but it's a very brief description and I can't give you a detailed answer today. Okay, next, pet restrictions, nothing mentioned in the bylaws or the declarations regarding size. Can a restriction be created as a rule? Probably yes, because that is something that is technically supported by the governing documents already. Does an emotional support animal documentation overrule pet restrictions, or can one allow small dogs? Can one only allow small dogs as ESA? Emotional support animals can be most types of animals, including chickens. They do override the governing documents, but the owner needs to actually request what's called a reasonable accommodation of the association's regulations. If they don't request it, you can still send your demand unless you have reason to know that, one, this person has a disability, and two, that animal is an emotional support animal that is serving that disability. Okay, next question. Not sure if required to do bot days, or I don't know what that means, so we're going to skip to the next one. Sorry. Are new owners grandfathered if they purchased the condo with changes that were made in their unit? Depends whether an estoppel certificate was requested and issued. Potentially yes, but that's a tough one, because it really depends whether there is an estoppel defense raised when the association goes after this person for the condition that shouldn't have been allowed in the first place. So the answer is it depends. Sorry. Occasionally I do have to provide the lawyer answer. Okay, once a violation reaches the fining stage and the fine is levied and applied, if the owner still doesn't remedy the issue, what should the next step be? Should the violation be closed and a new violation issued? No, that's a continuing violation. So when we set $100 a day until it's cured, up to $1,000, unless your governing documents say it can be more, that's your answer. You levy it in the first place as a continuing violation, and you continue that fine until it reaches $1,000. If the association doesn't see curative action, don't go through a second fining process, go through the enforcement process. Tell them, we've already fined you for this, you're not curing it. We're going to consider it a nuisance, or we're going to pursue the violation under whatever other provision of the governing documents we're able to go after you for, and go after it that way. Go through the standard enforcement process rather than just levying fines that for a lot of people just don't mean anything unless you're actually going to file a lawsuit to also enforce the fines. Okay, where the unit has a lease, the violation's logged. Is it required to send notice to the tenant as well, or just the owner? Is the association responsible to the tenant in that matter? I would send it to the tenant just so that you're placing everyone that might be responsible on notice of the violation and what they're supposed to be doing. Because if you don't send notice to the tenant, then you might not be able, if you eventually decide to evict that tenant, you might have problems. Or if you decide you want to sue the tenant, whatever you're trying to accomplish, you might have a problem. So I always will address the letter to the owners as well as the tenants when I'm sending a violation notice, and there are tenants that are responsible for the violation. Fireworks used during designated holidays exemption. That's not the subject of this, and I don't see a specific question, so I hate to tell you, but I'm going to skip that one. What is self-help? It's when the association actually goes onto the property and cures the violation itself. In other words, someone has a violation on the property. The grass is overgrown. It's 8 feet tall. The association sends a notice. The owner just ignores it, doesn't do anything. If the association's governing documents say they can do it, then the association sends a notice saying, instead of just going through the standard enforcement process, we're just going to physically send someone onto your property and cut the grass and charge the cost of cutting your grass and potentially administrative charges, if those are authorized in the governing documents, to you as the owner, potentially as an assessment, if that's what the governing documents say. So that's what self-help is. Once fined, can the owners be given a new violation because it wasn't cured? We answered that separately. Does the fine max include legal fees? No, unless you are pursuing enforcement of the fines or the governing documents themselves. Do the members of the fining committee need to be residents of the association? Technically, no, but they probably should be. I'm not aware of anything, and that would probably be just a matter of, frankly, me re-reviewing the statute. I don't want to give you an absolute yes or no, because frankly, I don't know offhand, and I'm not looking at the statute right now to answer, but the statute's where you're going to find that answer. And if it doesn't say anything, then you might be able to use someone who is not a resident of the association. Now, when you talk about residents, you put that in caps. Keep in mind, residents doesn't equate to members. The members are the people that own property. So if I own property, let's say I own 20 properties, I can only live in one of them in reality. So I'm only a resident of one of them. I'm still a member of the other communities, so I would have the right to be on that committee. Keep that in mind as well. If we decide to fine, the fining committee approves, the violations continue. Can we continue up to the 10,000 maximum without reconvening the committee? The answer is yes. If the CAM's employed by the management company, can they serve on the fining committee? The CAM cannot serve on the fining committee. That's the end of that question. I am the CAM and that was the answer. I'm a CAM and a homeowner here. Well, you're serving in two potential capacities there. And the answer is, there's a potential conflict there. The answer is, candidly, I don't know offhand. I can't answer that immediately. That's something you probably want to discuss with both the association's counsel and the management company to see whether that's something that you're going to be permitted to do outside of your employment.
Alan, let's do two more. I know you have some meetings coming up.
I'm sorry?
I know you have a couple of meetings coming up in your swamp. Do you want to just do a handful of more?
Sure. Like I said, I'm doing the until I run out of breath routine. I'm almost there. So I appreciate you kind of cutting me off. How many people make up the fining committee? 3 pursuant to statute, could be more if you want. What happens to a legitimate violation if the fining committee meeting waives the fine? What remedies does the HOA have to ensure compliance? You just go through that standard enforcement procedure that I described earlier. You send your offer for pre-suit mediation, or whatever your enforcement policy dictates. That should be 1, 2, or 3 letters directly from the association, so you're not immediately incurring attorney's fees. Then your attorney, if you're working with our Orlando office, that's me, I'll send a letter out that says, hey, listen, if you don't cure this, we're going forward to an offer for pre-suit mediation. And then you involve our litigation department if you're one of our clients. And our litigation department sends the offer for pre-suit mediation. If we don't get an answer, or if mediation is not successful, you file your lawsuit seeking either an injunction or some other remedy. Okay, doesn't the board have to hold a meeting first with 14 days notice to the owner to allow the unit owner to be present to plead their case so the board can determine if the unit owner is to be fined? I answered that during the presentation. Yes, the board needs to decide. Maybe I didn't clarify, and I'll do that now. The way the board decides literally anything is either via a meeting or something in writing that basically says this was a unanimous decision and it's a resolution of the board. Okay. If there's no finding committee, can they be charged on services? I guess that's a self-help services type of deal. And the answer is it depends on your governing documents. If there's no finding committee, you cannot fine, period. Can you share from dealing with other associations who's responsible to identify infractions? Is the board, owners, what's their role? In other words, who's supposed to be doing this? Your CAM is generally going to be responsible for going through the neighborhood, but you got to look at your management contract. If your management contract doesn't make them obligated to do that, make them obligated to do that and just pay whatever the extra is to make that happen so that you don't have your board having to drive through the community and look for these violations. If you don't have a CAM, or if your CAM isn't doing it and isn't willing to do it, then yeah, it's generally the board, but the owners can report it and then have the board investigate or the CAM investigate in the interim when the CAM, most CAMs are only going to go through once or twice a week. So yes, the owners, the board, anyone can report this to the board of directors or the CAM, and then the manager will send out the notice, or if you're self-managed, the board will send out the notice or notices until those that are required by your policy have expired, and then it goes over to your attorney. If you don't have an attorney and you have violations and you're not doing anything with them, you need an attorney. If you don't have a policy, you need an attorney. So, I'm going to cut it off there. Actually, I'll answer one more because this is actually a really good question. Will failure to pay fines affect ability to run for the board? The answer to that is yes, it will. Because if you are delinquent, and we didn't discuss eligibility for the board, but I want to mention this. If you are delinquent by at least 90 days in any fine or monetary obligation to the association, you technically can't serve on the board. So that's the quick answer. I see we've still got 15 open. I think we're running up to the end. Jeff, if we've got some time, I might be able to get through those. If we don't, no worries. People are welcome to contact our firm, and we may or may not be able to answer their questions, depending whether there's any privilege attached and frankly, whether they're clients of ours or not. Well, let's make it happen. Okay, so if fines are not paid, can the board withdraw owners' access to common elements? Same answer as before. Once that reaches 90 days, you've technically got a monetary obligation that is past due 90 days. And yes, after following the board meeting requirement, you can suspend use rights, potentially voting rights, depending on whether you're in a condo or an HOA and whether it reaches $1,000 or not, et cetera. But the short answer is yes, after 90 days, after that fine was due to the association. In other words, after that 5-day notice that you're going to give once that fine is levied has expired. So you're looking at 95 days from the date you provide notice plus 1. So on the 96th day is when you can actually suspend those rights. Monetary obligation to be $1,000 or greater to suspend amenities or voting rights or both. So this is condo only, and it's $1,000 or greater to suspend voting rights only. What can we do if a tenant doesn't pay the fees to the association when the landlord is delinquent? So this is after you've sent your rent demand notice. What do you do if the landlord is still delinquent and the tenant doesn't pay? Technically, you could evict the tenant. That is the right that the statute provides the association, and the statutory form actually notifies the tenant of that risk. So what can we do? Well, you can pursue the violation in the way that you normally would. If it specifically pertains to the monetary obligations, you could pursue those rights in court. You can send if it's assessments, you send your statutory demand letters, you file your lien, and you file a foreclosure and damages lawsuit. If it's fines, you can file a small claims lawsuit. And, if you want, you can. And, this really only works in areas where there are high rentals needed, like Kissimmee and Miami are really good areas for the eviction process. But otherwise, you don't necessarily need to spend the money on an eviction if what we're seeing is, well, yeah, we're going to spend another $2,000 and we might be able to tack that onto the owner's ledger, but we're out of pocket another $2,000, and that one person that might have actually paid us is now not even in the property. But when you see that working is when they're going to put a new tenant in, you're going to send that new tenant the rent demand, and then you're going to evict them too if they don't pay. So that's my answer. What's the procedure for pre-suit resolution? How are mediators appointed prior to suit? The process is the association or the complaining party sends that offer to participate in pre-suit mediation. The way that the mediator is appointed, it's not an appointment, but the party that's sending that offer for pre-suit mediation selects 5 mediators that they'd be willing to use who are impartial and who are able to mediate the dispute. And the responding party needs to select one or more of those mediators that they're willing to use. So it's not a, well, you know, I'm willing to use a mediator, but not any of the ones you pick. No, you're going to pick one of my 5, or your response is not compliant with your obligations, and you're not going to be entitled to your mediator, and you're not going to be entitled to your fees and costs, excuse me, even if you win. So when you're talking about what is going to happen, you're going to send your letter and you're going to wait for a response. And if the party responds agreeing to mediate with one of your mediators, you're going to contact that mediator, schedule the mediation conference, and hold it. And if you settle, great. You've got a settlement agreement in place. It says whatever it says. If you're not able to settle, then the complaining party decides whether to actually file their lawsuit. And if they decide to, their attorney will go ahead and get it prepared and file it for them. That's it. What's a legal board meeting and what is considered illegal? A board meeting is anytime the board meets and discusses association business and decides on association business. Okay. What is illegal is when you don't provide notice of that meeting, or if you are holding a closed board meeting and it's not for the reasons that are stated in the statute. In other words, to discuss potential or ongoing litigation with your attorney, or to discuss employment matters. So if you're having the meeting, but you're not providing notice, or it could be if you're having that meeting via Zoom and you know that 20 of your members who would have attended don't have computers and don't have cell phones and don't have, you know, tablets that they can use to attend that meeting, and you don't give them the opportunity to attend in person, that could be an illegal meeting. A legal meeting is literally just one where you gave notice, you're holding it in an open forum, and you're making the formal votes and everything that you described, and you're only dealing with issues if you have an agenda because you're in a condo or because you chose to in an HOA that are on the agenda. That's it.
Alan, these are the last 3 because they're time stamped before 3 o'clock. So 3
Okay.
more, and we're going to call it quits.
Got it. We're concerned about liability if a homeowner lights fireworks on common areas. Oh, this is about the fireworks issue. Okay. How does the last part of the statute affect that? Well, if you're concerned about liability, you're required to allow them to light these fireworks. You're not required to allow them to do it in common areas. So I actually have a community in Kissimmee that had that issue on the 4th of July, where everyone was lighting their fireworks, but they were doing it from common areas. You can notify everyone in advance of those holidays when you're required to allow those fireworks. Just notify everyone in the community, however you want to do it. Hey, you know, we understand that you're allowed to do this, but you're not allowed to do it on common areas, and you're required to clean up everything on common areas. And just so you're aware, you and not the association will be held responsible for any damage done to any properties in the community by virtue of the fact that you're lighting off these fireworks. My recommendation for that one, have your attorney send out that notice. All right, we have a covenant restriction on how many vehicles a home can have. We see in society that older children stay home longer and get vehicles, so some are now over the limit. How can we enforce our covenants? My answer is I couldn't care what society dictates. I care what the governing documents dictate. You've got 2 options. You can amend your covenants so that you're allowing more per lot or per unit. I don't know if it was a condo or an HOA that you're in. You know, you can change that so that your governing documents actually allow for, let's say, 1 or 2 more vehicles. But keep in mind, if you choose to do that, you're going to potentially run across situations where there's not enough room on the street to actually get through. Or you can just say, yeah, I'm sorry, but you've got to figure out a way to store those vehicles in a garage or somewhere that you are allowed to store them on the property. If not, you'll have to store the vehicle off property. And we actually have some communities, or I've represented some communities where that was exactly what we had to do, because there just wasn't room on the street to allow more vehicles and still have it be safe. So that's where we stand on that one. And then the last one, according to Jeff, and I appreciate the cutoff because otherwise I would be still going 20 minutes from now. Is the HOA liable for non-performance or damages to homes by a contractor hired for the community? That's, I hate to end with an it depends, but it depends. It depends what the contractor is doing. It depends whether, it's something that chances are yes, you might be held liable, but chances are if there's damage done by one of your vendors, either your contract's going to say they're responsible for it and they need to indemnify, hold harmless, and defend the association, or your insurance carrier is going to end up covering whatever claims get filed. If they're small claims, you might end up paying them out anyway, just because they might be less than your insurance deductible. But chances are that's going to be the answer is for major damage. Either the person was negligent, meaning that they're responsible for it, or your insurance company is going to be responsible, or some combination where the insurance company is responsible and they bring in the vendor who was negligent in causing the damage as a secondary, kind of like a third party defendant that should be paying out instead of the association or the insurance carrier.
All right. Well, Alan, thank you so very much. Excellent. You got lots of compliments in the chat.